The meeting is being recorded. The recording will be available on the TRCM YouTube channel within 24 to 48 hours. So I encourage you to look for that if you want to listen to it again. All participants have been muted until our live question and answer period at the end of tonight's presentation. We do hope that you came with some questions, and I encourage you to share once we open up the floor after today's presentation for the live audience question and answer. Feel free to post your questions in the chat bar, or save them until the end when we open up the floor to live Zoom Q&A. Before we begin tonight's session, as we've done in all three previous sessions, we want to start with an opening song by Elder Sherry Kopanese.
So the song that I'll that I'll render for you is the song that I referenced that belonged to my late great uncle, the late Clifford Skeed, and this is the song he always rendered prior to going into any one of the lodges. So I'll use my shaker. He always used a hand drum, but I'll use my shaker to do that. Inga bindiga kiwigiwa Yahweh Yahweh Inda bindiga kiwigiwa Yahweh Yahweh Inda bindiga kiwigiwa Yahweh Inga bindiga kiwigiwa Yahweh So that was his song.
And we want to offer our many thanks to Elder Kopanese for sharing her song and allowing us to share that song with you as well. So this 4-part webinar series is an opportunity for us to reflect on the treaties and the treaty relationship and renewal. So it's looking forward and seeing how we can bring the treaties forward. So we thank you for joining us on this journey with us as we examine 150 years of treaty making, as well as taking an in-depth look at how settlers, newcomers, and First Nations people can live together today and in the future in a good way. After all, we are all treaty people, and the treaties are intended to benefit all of us. So this 4-part webinar series is a reflection of that ongoing and everlasting nature of the treaties, and we invite you to ask the questions, as I've mentioned. Think of how we can move forward together once we've completed these 4-part series and have that conversation. And so to help us to come to some of those thoughts and paths forward, we've gathered some incredible speakers. And if you were with us from the beginning of our series, you would have heard from our amazing elders, Elder Florence Painter and Elder Harry Bowen, who shared an elder's perspective on the spirit and intent of the treaties. Last week, we had Professor Aaron Mills, who helped us gain a better understanding of Anishinaabe law as he discussed the importance of kinship and the political power of family as it relates to treaty and the treaty relationship. And as I mentioned, if you were unable to join us, those 2 sessions are available on the Treaty Relations Commission of Manitoba YouTube channel, and I encourage you to view them, as I know that you will enjoy the discussion and conversation and learn some very interesting information. I've sat certainly with the elders many times, and each and every time I sit with them, I learn something new and use that as the foundation to move forward. So as the Treaty Relations Commission, we hope that those 2 sessions, while we know it's not all encompassing in everything, that it provides a foundation and some foundational thoughts on the treaty relationship from the First Nation perspective. We want to, in the last 2 sessions, shift to some of the how-tos. And during the latter part of both of those sessions, we started to receive some questions about, well, what do we do, right? And I think that's the biggest question that many of us want answers to is, so now what do we do? And so we hope that through the next 2 sessions, we can explore that with you. And one of the areas that I think is deserving of attention is UNDRIP. And we've heard a lot about UNDRIP in the last few years. And we know now that it is part of Canadian law. It received royal assent this past summer. And it's been offered up as a tool for to move forward in the relationship between First Nations and the Crown. And there's still a lot of unknowns, and I think there's maybe some assumptions about UNDRIP and how it fits into the treaties and the treaty relationship, and who better to help us walk through some of that but Brenda Gunn. And we certainly rely a lot at the Treaty Relations Commission. We have a great relationship with Brenda, and she's an expert. I think I can bravely say that with a lot of certainty, and one that we rely on as well to help us guiding us through in these kinds of conversations. So we're happy that she's able to join us. Just if you for some reason have not heard about Brenda, I'm going to share a little bit about her. She is an associate professor at Robson Hall at the Faculty of Law here at the province of Manitoba. She's recently joined the National Center for Truth and Reconciliation as the academic and research director. She has a BA from the University of Manitoba and a JD from the University of Toronto. She completed her LLM in Indigenous Peoples Law and Policy at the University of Arizona. She articled with Sierra Legal Defense Fund, now EcoJustice Canada. She was called to the bars of the Law Society of Upper Canada and Manitoba. Brenda also worked at a community legal clinic in Rabanal, Guatemala, on a case of genocide submitted to the Inter-American Commission of Human Rights. She has also worked with First Nations on Aboriginal and treaty rights issues in Manitoba. As a proud Métis woman, she continues to combine her academic research with her activism, pushing for greater recognition for Indigenous peoples' rights as determined by Indigenous peoples' own legal traditions. Her current research focuses on promoting greater conformity between international law and the rights of Indigenous peoples and domestic law. She continues to be actively involved in the international Indigenous peoples movement, regularly attending international meetings, including the review of Canada before CERD and CESCR. She provided technical assistance to the UN expert mechanism on the rights of Indigenous peoples in the analysis and drafting of the report, summarizing the responses on the survey on implementing the UN Declaration. She developed a handbook on understanding and implementing the UN Declaration on the Rights of Indigenous Peoples, and that is quickly becoming one of the main resources in Canada on the UN Declaration. And she has delivered workshops on the Declaration across Canada and internationally. In 2013, she participated in the UNITAR training program to enhance the conflict prevention and peacemaking capacities of Indigenous peoples representatives, which continues to impact her research. So welcome, Brenda. We're certainly honored and happy that you're able to join us. And as Brenda's doing the presentation, again, I encourage the audience, please take note of questions. Brenda will be available at the end to answer any questions that you may have, and hopefully she and I will have some opportunity, as we did in previous sessions, to have some dialogue on her presentation and any questions that perhaps I have as well. So Miigwech, Brenda, I'm going to turn it over to you, and again, welcome.
Thank you, Commissioner. Good evening, everyone. Thank you for that very kind introduction and for reading my bio. I really am honored to be invited to speak here on this series about thinking of treaties moving forward. I'd like to thank the elder for her song and for starting us off in a good way, and particularly thank her for helping me be grounded and centered for this presentation. It's been a very busy day, and so I really appreciate having that moment to sit and get myself ready for this presentation. So I know the title of my talk focuses on the UN Declaration on the Rights of Indigenous Peoples and what that may offer to our conversations about treaties moving forward. But I'm actually going to start a little bit broader than that. I want to start by actually thinking about how international law more generally has viewed Indigenous peoples and Indigenous treaties. And then I want to think about what does the UN Declaration add to the mix, noting that it's one of the more recent international instruments. And then if time permits, if I'm not too long-winded about this, I'll try to talk about what are some of the implications of this international recognition. And I really want to highlight here that I hope my contribution to this series is really adding to what the elders and other speakers have said. It's not meant to challenge or change anything that they've said, but really my presentation today is focusing a lot in countering what Canadian courts have said and what Canadian governments say about the nature of treaties. And so I see my work as sort of supporting the work of elders who have always talked about our treaties as nation-to-nation treaties. And so I want to look at that position from an international law perspective. And to give away the ending, I'm actually of the opinion that even in international law, it's fair to say that the treaties that were signed, Treaty 1, are international treaties from the international law perspective. And so I want to think about, well, what does that mean for us here? So I'll try to keep my presentation shorter, though I can be long-winded. So hopefully I'll keep it to about 40 minutes, and that'll give us lots of time for conversations and questions. And so, as I've already alluded, the challenge that I see, at least from my international law perspective, is that there's this early decision by the Supreme Court of Canada where it concluded that the treaties between Indigenous peoples and the Crown were not international treaties, but they were sui generis. This is the Latin term that they used. And it is this decision that really paved the way for the domestication of Indigenous Crown treaties. And from that perspective, that these treaties are sui generis according to Canadian law, and so they're really just domestic agreements, that approach has really, that decision, that perspective has been used to support the Crown's position that Treaty 1 and the other numbered treaties are land surrender agreements in which Indians gave up their claims to occupancy and use of those lands in return for gifts and annuity payments. And so for me, that's the challenge. That's sort of where we are from the Canadian legal perspective. So how do we move along from there? How do we move forward when we have this Canadian legal decision and this policy taken by governments that these treaties are land surrender treaties, particularly, as I said, when elders have always told us that they are nation to nation, that they are international treaties. And so through some of the research that I've done, it really became apparent to me that this position that the court took wasn't really well founded in international law. And I'm not going to spend a lot of time teaching everyone all the ins and outs of international law. I'm not sure that's what anyone wants to do on a Wednesday night. But I do want to provide a bit of a background on international law to try to better contextualize that decision, because I actually think when the court decided this in the Simon case, it was this sort of really narrow snapshot moment that wasn't sort of well grounded in a broader understanding of international law. And so I want to share some of that history with all of you. But before I get into that, I want to kind of continue to try to articulate some of the ways in which the Canadian courts, Canadian people, and Canadian governments have tried to argue or understand why treaties are not international agreements. And so the basis of those arguments are in a lot of ways based on just racism, but they're based on ideas. They sort of, sometimes they say it explicitly, sometimes not so much. But the arguments include ideas that Indigenous peoples aren't peoples. And so there's various decisions we've seen over the last couple of hundred years in Canadian and American courts that have talked about Indigenous peoples as not being peoples. And so once you fail to recognize the essential humanity of Indigenous peoples, it becomes easier to erase these treaties as international agreements. The other reason that people sometimes posit as why treaties aren't international treaties as we understand international treaties is this idea that treaties can only be concluded between nation states, right? Those formally recognized states that are part of the United Nations, for example. And then a third reason that is sometimes put out there is just the sort of colonial reality of Canada, right? That somehow, well, Canada exists as a nation state now, and Indigenous peoples are existing within this nation state. And so somehow we just can't imagine treaties being international. And it sort of is, treaties are used to kind of perfect that colonial reality in Canada. So these are the ways in which I've seen people try to undercut the idea that treaties are international. And I want to go through and I want to challenge those ideas by not sort of speaking to what the elders and previous speakers have already spoken to in this series, but focusing on another perspective, the perspective that I have spent some years looking at, which is the international perspective. And so, as I'm sure many people have known and that has been talked about, that there has been a very long history in what is now Canada of treaty making between Indigenous peoples and the British Crown. And at least since the 1700 treaties were signed. And it's fair to say that when treaties were signed, including the numbered treaties, that both parties, the British Crown, the Anishinaabe of this area, all had rich histories of engaging in treaty making. And they brought those traditions and laws and protocols with them to the negotiations. And from an international law perspective, treaties have always been recognized as fundamental in international relations. Especially, treaties have been important for developing peaceful and cooperation between nations. And under international law, there's a wide variety of treaties that are concluded, right? And the type of treaty that would be concluded would vary depending on the purpose. And so in international law, if we were all sitting in a room, I might, see what people could brainstorm, but, maybe I'll just share a few of the different treaties that exist. So one of the common treaties that we see are peace and friendship treaties. These are treaties that are often negotiated to end wars or to create alliances between nations. There's also military alliance treaties, so treaties that states enter into to agree to protect one another. So I don't know if anyone's heard of NATO, for example, but there's the North Atlantic Treaty Organization. So where various states have come together to protect one another, and these have long existed in international law, as well as, I think, from many First Nation perspectives, these are the types of treaties that have long been engaged in. There's also trade agreements. So people might know of NAFTA, or what we now refer to as the new NAFTA, or the US-Mexico-Canada agreement. It doesn't have a great acronym, so we just often call it the new NAFTA. There's also human rights treaties. And these treaties exist from the UN system and protect a wide range of different human rights. So we have treaties that deal with racial discrimination and civil and political rights and economic, social, and cultural rights, and discrimination against women and rights of persons with disabilities and migrant workers. And so under international law, we see a range of treaties that exist, and there's nothing that sort of is required in order for a treaty to exist. There's no formalities that need to be followed necessarily, but the important aspect is just that in order to understand the type of treaty it is, you look at the context, and I think here what I want to highlight is that both parties to Treaty 1 and the number of treaties had this rich history of engaging in a range of treaty type of relationships. And so knowing that both parties had a rich history of treaty making, I want to give you this much history of international law and how international law has approached Indigenous peoples. In part because many people start with this assumption that international law has never recognized Indigenous peoples as peoples or as subjects of international law. However, that's not the full story. And so for me, we can turn to the 1500s, and we can see that initially from the period about 1500 to 1800, these are big swaths and general numbers, international law did in fact recognize Indigenous peoples as sovereign nations, recognizing their autonomy and their capacity to enter into treaties. So at the beginning of international law, Indigenous peoples were peoples and were part of the nations. And so people like Francisco de Vitoria in around the 1500s, he specifically posited that Indigenous peoples in the Americas were rational human beings who were the true owners of their land. And so we see early on the starting point in international law recognizing the ability of Indigenous peoples to engage in treaty making, and treaty in that international sense as we generally understand treaties. This continued on into the 1600s when Hugo Grotius also recognized that Indigenous peoples had the capacity to enter into treaties based on natural law. And Grotius's approach was that Indigenous peoples were peoples, and so they had the same rights to enter into treaties as all peoples. It wasn't until much later, the 1800s, when people began to, when international law started to shift from this focus of nations, including Indigenous peoples, to what we now think of as the nation state or states. And it was at this time that international law slowly began limiting the recognition of Indigenous peoples standing in international law. And it was through this process of recognizing the sovereignty of the state that rules began to develop, including the idea that there should be no outside interference, right? That one state shouldn't interfere with the internal affairs of another state, and that all states should be free, independent, and equal. And during this time, we start to see international law shifting to become a legitimizing force of colonization and the British Empire and other empires as well. However, even at this time, though, people like de Vittel noted that a state or an entity wouldn't lose its independence simply by placing itself under protection or making an alliance with another state, so long as self-government was retained. So this probably feels very technical and very old international law, but here I want to highlight that even when international law was shifting to really just recognize states like, you know, what eventually becomes Canada, et cetera, and all the European countries, there was still a recognition that peoples could align themselves with others and not lose their essential sovereignty. And so I see, even when we look at the Royal Proclamation of 1763, that in the written text talks about the Royal Proclamation being about the several nations or tribes with whom we are connected and who live under the protection, right? This sort of grand proclamation from the King in 1763 that's gonna, from the King's perspective, lay out the process of settling what becomes Canada. Even the words that he used in that proclamation for people with whom we are connected and live under our protection, at the time in the 1700s, that meant that was not a way to take away the sovereignty of another nation, right? That just because you align yourself with someone else didn't mean you lost your standing. And so the point here is that for centuries and centuries, Indigenous peoples were recognized as having the capacity to enter into treaties. And it wasn't really until the 1900s that we see clear statements by international scholars and some international courts that say that treaties between Indigenous peoples and colonial governments are not international treaties. And so one of the first instances we see in the Canadian international law context is in this 1960s textbook. And the author McNair talks about that the modern doctrine of international law is that Indigenous Crown treaties are not international law. But he even includes a footnote in his writing and says, but I should note that in the past, these treaties have been recognized as international treaties, and points to several sources and ends up pointing specifically to the Maori and the Treaty of Waitangi, and also some recognition in the US, etc. So even at a point in time where international law was trying to say Indigenous Crown treaties are not international, there was all these caveats and footnotes, but kind of saying, but they have been recognized, and no source or no reason being provided other than saying they're not. So that's where we get to this point in time. And I think when the Canadian courts look at this question, they just take that snapshot in sort of the early 1900s and say, they're not Indigenous Crown treaties. Treaty 1 isn't an international treaty. The court wasn't specifically looking at Treaty 1, but they were speaking very broadly. But they didn't actually look at, well, what did international law say at the time the treaties were negotiated? And so that's what I want to come back to in a little bit. But I want to kind of skip a bit of time, and I want to get us to present day international law, because what we're seeing now, again, starting in the 1990s, is a recognition, in fact, that treaties were international treaties, right? So in a landmark study done by Special Rapporteur Martinez in his study on treaties, he recognizes that treaties that were made between Indigenous peoples and other states were international treaties. He says there's no sound legal argument to sustain an argument that Indigenous peoples have lost their international juridical status as nations. Right? He says that in establishing formal legal relationships with people overseas, the European parties were clearly aware that they were negotiating and entering into contractual relations with sovereign nations, with all of the international legal implications of that term during the period under consideration. So he brings us back to this point now in 1990, saying all of those arguments that were coming out in the early 1900s were not based on any actual rule of international law, but were really just, he doesn't quite say it as explicitly, but really just saying like those were just racist decisions that were being made and weren't well founded in international law. And he's particularly concerned what he calls the process of retrogression, where states started coming together through the League of Nations and the United Nations to start to erode the recognition of Indigenous peoples' original status as sovereign nations. And so by the 1990s, we see the UN engaging in studies and research and saying, you know what? These treaties were and always have been international treaties. And the parties, when they engaged in these negotiations, were intending to engage in treaties as we understand them in international law. From the work that I've done and working with the elders here and elsewhere, I think it's important that we also recognize that treaties aren't just sort of, we're not just saying that it's international law that should govern them, but there is an Anishinaabe law that very clearly governs and informs our understanding of treaties. But really the point that I'm trying to come in at here is that this position in Canadian law and that Canadian governments have that say treaties are not international is not well founded at all. And so the UN continues with this recognition of the standing of Indigenous peoples to enter into treaties with the UN Declaration on the Rights of Indigenous Peoples. The UN Declaration preamble recognizes that the rights affirmed in treaties between states and Indigenous peoples are matters of international concern, interest, responsibility, and character. So here again, we see the UN Declaration in 2007 going back to those original positions that treaties are in fact international treaties. Article 37 of the UN Declaration then goes on to recognize the right of recognition, observance, and enforcement of treaties concluded with states, and the right to have states honor and respect such treaties. And then I don't have a lot of time today to talk about another declaration on the rights of Indigenous peoples, but after the UN Declaration on the Rights of Indigenous Peoples, there's also the American Declaration on the Rights of Indigenous Peoples that focuses about the rights of Indigenous peoples in the Americas. So all the way from Canada, all the way down to Argentina and Chile. And here in the American Declaration, the recognition is even stronger, I think, because it talks about the right to, again, recognize, observe, and enforce treaties concluded with states. But here, this right of recognition of treaties is to be in accordance with the true spirit and intent of the treaties and in good faith. So here we see the international law now starting to recognize the need for states to recognize, observe, and enforce the true spirit and intent of treaties. The American Declaration then goes on to say that when interpreting treaties, we should give due consideration to the understanding of Indigenous peoples as regard to the treaties. And then it goes on to provide that when disputes cannot be resolved between the parties, these disputes shall be submitted to competent bodies, including regional and international human rights bodies. So from my perspective, when we look at international law and when we look at, 500 years of international law, there's really just a very short period of time, maybe 50 years or so, where international law wasn't fully recognizing the ability of Indigenous peoples to engage in treaty making, at least international treaties. That doesn't mean it was right, but just the point being that most of international law history actually did recognize the rights of Indigenous peoples to enter into treaties. And so I've talked a little bit about the UN Declaration and its provisions in relation to treaties. So maybe before I go on to talk a little about, so what does it mean if these treaties are international treaties? And particularly, so what, given that, as the previous speakers have noted, Indigenous law and Anishinaabe law has a significant role to play in. And so why am I throwing international law into the mix? I think it might be helpful if I talk a little bit more about the UN Declaration and why I think it's helpful and useful in the conversation about moving forward with treaties. So when we're trying to understand why there's a declaration on the rights of Indigenous peoples, I like to turn to the preamble and the preamble, for those who don't know, really set out the context for the UN Declaration and help us provide some guidance and interpretation for the provisions. So when you read the UN Declaration preamble, it tells a really significant story, and I think helps us understand how the UN Declaration may be helpful in this process of moving forward with treaties. First, the preamble affirms that Indigenous peoples are equal to all other peoples. So first, included in that statement is the idea that we are in fact peoples. So Indigenous peoples are peoples with all the rights that come with that. But we're not talking about Indigenous peoples being equal in that really formal equality, treat every single person identically the same. The preambular paragraph goes on to say that we also are affirming the right of Indigenous peoples to be different and to consider themselves different and to be respected for those differences, right? So yes, we're peoples, but we're also Indigenous. We're Anishinaabe, we're Métis, and that we have to celebrate and appreciate those differences and make sure those differences are respected and protected. The UN Declaration preamble also says that the United Nations is concerned that Indigenous peoples have suffered from historic injustices as a result of colonization and dispossession. So here we have the United Nations recognizing the negative impacts of colonization on Indigenous peoples, particularly highlighting the problems of removing Indigenous peoples from their lands, territories, and resources. And that this dispossession has really negatively impacted the ability of Indigenous peoples to control their own futures. The next point, which I think is really important in the Canadian context, the United Nations says they're convinced that the recognition of the rights of Indigenous peoples in the UN Declaration will enhance harmonious and cooperative relations. right? So people are afraid that if we recognize the rights of Indigenous peoples, if we implement the UN Declaration, that somehow it's going to tear Canada apart, right? Because they have some sort of false belief that Canada is mostly a peaceful, okay country. And what the UN Declaration is saying here, and what the UN is saying, is that in countries where colonization occurred, where dispossession continues to happen, those states are broken. And that if we want to fix themselves or reconcile, as we talk about in Canada, that we must do so on the basis of recognizing the rights of Indigenous peoples. And that'll help us shift the relationship from a colonial relationship where governments like Canada and the provinces make decisions for Indigenous peoples and don't make them particularly well, to a new relationship that is now going to be based on principles of justice, democracy, respect for human rights, non-discrimination, and good faith. Right? These values that Canadians espouse all the time and say we are hoping to live up to. So by recognizing the rights of Indigenous peoples in the UN Declaration, we can actually begin that process of reconciliation by shifting that relationship and basing the relationship now not just on colonial assertion of power, but rather on ideas of justice, democracy, respect for human rights, non-discrimination, and good faith. And so then the UN solemnly proclaims the UN Declaration as a standard of achievement to be pursued in a spirit of partnership and mutual respect. Here again, just another reminder to Canadian governments that they cannot go about implementing the UN Declaration on their own. They must work with Indigenous peoples in this process of implementation. Otherwise, it's just perpetuating that same colonial problem of governments making decisions for Indigenous peoples. But what the UN Declaration is really about is about shifting that relationship where Indigenous peoples have control over their own internal affairs. And so with that understanding of why we have a UN Declaration, how do we go about approaching it? Hopefully you can start to see why, from the Truth and Reconciliation Commission's perspective, that the UN Declaration provides the framework for reconciliation, right? Because it sets out the way in which we can start to shift that relationship and for Indigenous peoples to have greater control over their own affairs. And so time is very quickly passing by. And I do want to provide just some really basic information about the UN Declaration, because I think there's a lot of misunderstandings or a lack of understanding about the UN Declaration, in part because not everyone studies international law, right? Even not every lawyer studies international law. So I think it's helpful to understand that the UN Declaration on the Rights of Indigenous Peoples is a resolution of the UN General Assembly. That means the declaration became part of international law and part of Canada's international human rights obligation when that vote happened in September 2007. So even though Canada voted against the UN Declaration, the declaration still had legal effect in Canada as of 2007. However, what we saw was Canada being against the UN Declaration and it being very challenging politically to get any sort of movement on implementation. So as a declaration then, the UN Declaration doesn't need to be ratified or signed. There's no point in time where Canada has ever or will ever sign the UN Declaration on the Rights of Indigenous Peoples, because it's not a treaty. Ratifying and signing is what you do for human rights. Treaties, like those I mentioned earlier, the ones on civil and political rights and economic, social, and cultural rights, The declaration, Canada's only opportunity to try to impact the legal application, was at that General Assembly vote, and Canada lost the vote. The vast majority of states voted in favor of the UN Declaration. And so that means that the UN Declaration is part of Canadian law, that there's no further action that was needed by the Canadian governments to begin to implement it. But when politically they weren't in favor of it, it was challenging to do. But as a member of the United Nations, Canada has always been expected to implement the UN Declaration and uphold the rights within the UN Declaration in order to be viewed as upholding their obligations, right? One of the things that I really like about the UN Declaration, and one of the reasons that I think the UN Declaration is an important tool in the process of moving forward, is the fact that when you read through the various provisions of the UN Declaration, you can see how all of the rights that are recognized are grounded in Indigenous people's own customs, laws, and traditions, right? So the UN Declaration isn't giving Indigenous peoples any rights. It's merely recognizing rights that have always existed, but have been ignored by states. And so in this way, we say the rights are inherent. And importantly, Indigenous peoples were active through the whole negotiation process and made sure that when we talk about Indigenous peoples' rights to lands, territories, and resources, that it wasn't just from a Western economic perspective, but the provision actually includes references to Indigenous peoples' rights to maintain and strengthen their relationship with the lands, for example. And so the UN Declaration really can be seen as another way in which the Canadian state is required to really recognize Indigenous people's own customs, laws, and traditions, including Indigenous people's understanding of treaties and understanding treaties from Indigenous people's perspective, including that idea of the true spirit and intent. And so just maybe one final point on this background on the UN Declaration is just a reminder to everyone that the UN Declaration sets out the minimum standards, right? So it is the floor, not the ceiling, meaning that when we get to the point where Canada has fully implemented the UN Declaration, we haven't reached the best that it can be, but we've just sort of now are finally recognizing the bare minimum human rights for Indigenous people. So an important goal, but recognizing that that's the bare minimum. So what's all in the UN Declaration? Given that my time is almost up here today, I'm not going to walk you through all 46 articles and read them out one by one. That probably wouldn't be very exciting for anyone. But I want to give you a little sense of what's included in it. I have already mentioned the article that recognizes treaties, but I want to talk a little bit more about what's in there so that you can understand where the treaty provision fits in, and more, I think, about why and how the UN Declaration is useful in thinking about moving forward with treaties and treaty implementation in Canada.
Yeah.
So the UN Declaration, Article 1 and 2, again picks up on that idea that I've already mentioned about equality and non-discrimination, right? So recognizing that Indigenous peoples are equal to all other peoples, and that Indigenous people should not be discriminated against for being Indigenous. Then importantly, Article 3 recognizes the right of Indigenous peoples to self-determination. Self-determination very simply means that Indigenous peoples have a right to control their own internal affairs and to set out the terms of the relationship between Indigenous peoples and the state. And so when we're talking about treaty territories and treaty nations, again, that relationship between the state and Indigenous peoples was initially described and determined by the treaties. After we go to Article 3, Article 4 is about self-government and autonomy. There's a range of rights that relate to self-government and autonomy, including the right to determine our own citizenship, the right to establish our own institutions, the right to continue on our own customs, laws, and traditions. There's provisions that relate to life and security. Interesting little side note, the international law has started to recognize that the right to life in relationship to Indigenous peoples includes the right to lands, territories, and resources, and to have those lands be healthy. So a healthy environment is instrumental to Indigenous peoples' life and security. Also provisions against forced assimilation. There's many provisions that relate to culture and language and type of rights. So there's also provisions related to education. There's a really interesting provision that recognizes the right of Indigenous peoples to Indigenous language education, regardless of where they live. So whether they're on reserve or off reserve or in an urban center or a rural center, Indigenous peoples have a right to education in their Indigenous languages, a right to education in their own Indigenous ways of educating and by elders, for example. There's provisions about the rights of Indigenous peoples to their own media, but also a provision that says Indigenous peoples have a right to have all public information accurately reflect their own aspirations. And so curriculum and any statement by government should really be accurately reflecting Indigenous people's own aspirations. There's a range of political and economic rights. There's also provisions, as I've mentioned, about lands, territories, and resources. And there's provisions building off that self-determination, that idea of Indigenous peoples having a right to participate in decision-making. And related to that idea is the idea of free, prior, and informed consent, so that Indigenous peoples, when our rights are specifically and especially impacted, including anything related to treaties, that Indigenous peoples have a right to be part of that decision-making process and to consent to any actions that might impact our rights. So the UN Declaration is really broad, and even though there's only one provision that specifically recognizes the rights to treaties, I think it's important that we understand all of the rights in light of the treaty history and reality in Manitoba. So when we're looking at the right to education that's discussed in the UN Declaration, I think we want to connect that to existing understandings of the treaty right to education, for example, right? So we take Indigenous law and Indigenous understandings of the treaty, and that helps us inform and understand the general rights in the UN Declaration. And so, as Commissioner mentioned in the introduction, Canada has taken steps to begin implementing the UN Declaration, and that one of the biggest steps they've taken is by passing federal legislation that clarifies that the UN Declaration applies in Canada. My position and the position of many people I work with has always been that the UN Declaration always applied, but not everyone understood those rules of international law. So we've clarified that it applies. The Canadian legislation also requires the federal government to start to review all of the laws to ensure they're consistent with the UN Declaration. Canada is required to develop an action plan, so come up actually with a plan of how they're going to implement the UN Declaration. They must do that with Indigenous peoples, and Canada must report regularly to Parliament on what it's doing to implement the Act. And there's just one last provision that is maybe worth highlighting, and that's the idea that the UN Declaration Act, or what was used to be called Bill C-15, it clarifies that nothing in the Act can diminish or extinguish any rights recognized in Section 35, so Aboriginal or treaty rights. And so while it was important to put that in the legislation, right, that implementing human rights is about lifting people up, not about taking away existing recognitions, that recognition also exists in the UN Declaration, because the UN Declaration itself also says that nothing in the UN Declaration can be interpreted as taking away from anything. So the UN Declaration also cannot undermine any existing treaty rights. Again, it's about lifting people up. So I think we're just about out of time here. I just want to maybe on the last sort of minute or so, just maybe talk about what would it mean if Canada started to recognize the treaties as international treaties. There would be some interpretive principles that would apply. So under international treaty law, parties are not allowed to justifiably infringe the terms of the treaty. Also under international law, it means that one party of the treaty cannot unilaterally modify the terms of the treaty. And so there are instances in Canadian courts where they've tried to say that certain actions of Canada, like the natural resource transfer agreements, that somehow limited and narrowed the treaties. Under international law, that's not permissible. I think also one of the things that I've heard from Indigenous peoples around the world as to why they've pushed for recognition of treaties as international treaties is in part recognizing that domestic courts, Canadian courts, haven't done a good job. And so hoping to come up with mechanisms internationally that may be useful when disputes over treaties arise. So I think with that, I will end my presentation with all of you, and I look forward to your questions.
Wow. Wow. I want to thank you, Brenda. That was a powerful presentation, and you're most definitely correct when you say that not a lot of people know international law, even lawyers, Canadian lawyers. And I had my picture up because I was writing furiously, learning myself as you went along and did the presentation. So thank you again for that. And I will no doubt be going back and replaying this and trying to remember some of the things that you had shared with us. There, just as we wait for some comments, and I don't think I see any chat questions come up yet, so I'll try and carry a bit of the conversation. There's some parallels, I guess I can see between Canadian law and international law, in the sense that you see these waves of decisions that have come through where First Nation, like if we talk about Canadian law, which I can only speak about, right, is that there's some narrowing of First Nation rights or Aboriginal and treaty rights through court decisions. And then you get through a pace or in time, different, like in the 70s, you'll see different court decisions. In the 90s, you'll see different ones where they broaden the definition or implementation or understanding of Aboriginal and treaty rights. And then you go back to some of the narrowing. They get too broad, and then you'll have courts trying to narrow some of those again. And it raises the question in some ways, and I think the UNDRIP speaks to it, or is these competent bodies to address issues related to Aboriginal and treaty rights. And I mean, in Canada, the only place that First Nations people have had to go to advocate for breaches relating to, or the lack of implementation relating to that, to treaties and Aboriginal rights, is the Canadian court system. And so, you have a court system that will go so far in understanding, and there's a number of treaty principles that the Supreme Court of Canada itself has enunciated in terms of helping the parties to implement treaty. But you see the Canadian court system only going so far. It's a self-preservation system as well, right? So they're only going to go so far. So I'm really latched on to your comment about the need to have competent bodies to address these. And is that something, or where do you see that going, and how can that be a tool to help us implement and renew this relationship?
Yeah, that's a really great question. And, I agree with you that we have these, these ways of recognition, which is kind of why I wanted to broaden us out, right? And that's why I took us on the journey back to the 1500s, when I'm sure most people were like, I don't really care about what international law said in 1500s and Grotius what. But I think it's really important because I think far too much of our understanding, or what people think they know about Indigenous Crown relations, is really based on a very narrow understanding. And I think for me, that's part of what this series has been about, is challenging the things that we think we know and getting us to look broader. And so I think it's really important when we're talking about treaties to say that, like, if our timeline of international law is this big, there was like just a very small period in time where international law didn't recognize Indigenous peoples. And I think for me, part of that, the importance of that, is also then recognizing that when treaties were made, when Treaty 1 was negotiated, the Indigenous law that was invoked at that time was recognized as a legitimate legal system, and that the people who were engaging in that process had the capacity to enter into these relationships, which gets me to your question about competent bodies. I think this has been something that I've thought a bit about over the years, in part because I remember in the mid-2000s being part of one of the international treaty seminars, following up on the work of Special Rapporteur Martinez's study on treaties. And everyone was like pushing for, greater recognition of the international nation, the international status of the treaties. And I was like, okay, this aligns with, what I've been taught by elders and etc. But, what do we want? Like, do we want the United Nations? Do we want just more state governments involved to negotiate or interpreting treaties? Like, is that actually going to get us anywhere better? Because aren't you just going to have the same perpetual problem? And I think the answer for me is that we're not necessarily seeking the UN in that, like, the nation states to be the arbiters, but rather thinking about the way in which the UN engages experts and independent experts in various areas. So, for example, I think people are very interested in whether or not the UN expert mechanism on the rights of Indigenous peoples, one of the 3 specialized bodies at the UN, whether or not that body could be a place where you bring disputes, right? And so the UN expert mechanism on the rights of Indigenous peoples has 7 independent experts that sit with the experts representing the 7 different regions of Indigenous peoples. And if I try to name them all, I'm going to forget someone, but there's the Arctic, North America, Latin America, and South America, Central Europe, Asia, the Pacific. I always forget one. Anyways, so you actually have experts, so independent experts that are sitting there who are expert in human rights and Indigenous rights, and many of them are Indigenous, right? So Chief Wilton Littlechild, for example, sat on the UN expert mechanism. So if you had a human rights body where you had independent experts who are, hopefully the majority of them are Indigenous, that could be a place that you could go to bring the dispute. So I think when we're talking about competent bodies, we're not just wanting nation states, but actually ideally Indigenous representatives and at least people who are well versed in Indigenous people's rights and understanding of treaties and the treaty histories.
Mm-hmm. Excellent. Well, I see just in that short time, some questions are popping up. So I want to give people, I could probably dominate all of your time here or monopolize your time rather, but I'll get to some of these questions. And so there are two questions that were posed. One is, how do newcomers, immigrants, refugees, etc., enter into treaties? I know in 94 calls to action, there is a call to change the oath of citizenship, but I'm wondering if all new settlers and newcomers are entering their treaties through the gate of the Crown.
Yeah, I think I'm not sure if I'm taking the question in the right direction, but what it made me think of is, the motto that the Treaty Relations Commission has engaged at various points, that we are all treaty people, mm-hmm. right? And so what I've always understood is the idea of including mention of Indigenous peoples and treaties in the oath is a way to bring newcomers to Canada into that treaty relationship, to have newcomers recognize that being here in Canada means being party to a treaty and having certain rights, but also certain responsibilities that flow through that. And that part of that might then be a need to have greater education to understand what those treaties are and what those relationships are, depending on where you are, where you end up geographically being based in Canada. And I think definitely there is a concern that if we use the oath, that, it's too much focusing on the Crown's perspective on the treaties, and maybe it's it's lopsiding the relationship. But I think people can also take it upon themselves to get that education, and that hopefully using that oath as a springboard to realize what they may be, what they may still need to know, and think about opportunities to start developing relationships with First Nations, and to really gain an understanding of what does it mean to be living in Canada, living in Winnipeg, living in Manitoba, living in Treaty 1 territory, right? What does that mean? And so while I can see the danger, I really hope that it's more of an opportunity to start learning more about treaties.
Yeah, exactly. And I think it's that acknowledgement that, as a new Canadian, there's a lot to learn, right, about your country and your responsibilities and the laws. And I think this just brings to the forefront that original relationship on which Canada was built and what it allowed for. And I think it just, as you said, brings the not only the rights that new Canadians are receiving, but the responsibilities as well, and the responsibilities to the original peoples. So thank you for that question. I see the boss has arrived now.
I think it's almost bedtime, and I think she just wanted to come in for a cuddle, but we can continue on. She will Oh,
Oh, there we go. Yeah.
Just
She
got my
says,
good
keep
night
going,
kiss.
Mama. Keep going. That's wonderful. Another question is, won't new and modern treaties such as Nunavut imply that Indigenous peoples are people and nations and negotiated with? I'm not sure that.
Oh, this is a really great question. And if only I had an hour to answer it. No, but I will say a couple of things. Canada had taken the position that even, sort of being silent, okay, maybe the historic treaties are treaties, but Canada always uses the term modern treaties to refer to land claim settlements and anything that's happening basically post 1970s, right? They use different terminology, I think in part of really trying to reassert Canadian sovereignty and this idea that Indigenous peoples are now within the Canadian state. And so the new agreements are not treaties, they're modern treaties, and really trying hard through the negotiations of the UN Declaration, through the treaty study that I mentioned undertaken by Miguel Alfonso Martinez. Canada has always tried to differentiate between historic treaties and modern treaties. And again, I think that's where the UN Declaration can be really useful in supporting arguments made by Indigenous peoples. That a treaty signed in 2000 isn't less international because Canada is a settled, or not, sorry, I don't want to use settled, is an established state, right? From the UN Declaration perspective, from the idea of self-determination, Indigenous peoples have a right to determine their relationship with the Canadian state, right? And so that treaties are one mechanism whereby Indigenous peoples can set out that relationship. Treaties are also important for Canada to have any legitimate argument to be a state, right? That not that they're the only government, but it gave a right to a certain amount of governance, right? And we, of course, the elders talk about the shared governance and the shared territory, but it was part of bringing the Canadian government in. And so from international law perspective, it doesn't matter if it's a historic or a modern treaty, right? Because all Indigenous peoples have that right to their own internal affairs and to set out how and in what way is that relationship happening with Canada.
Mm-hmm. I think that's an excellent point. We have a couple more questions here, and I'm being mindful of the time and try and get to some of these. Thank you, Brenda. So powerful. How does the doctrine of discovery fit into this history of ignoring Indigenous rights and international law prior to 1900s, or does it not represent a disregard of Indigenous people as having inherent rights?
Thanks. Yeah. It's, again, I sort of went through a lot of history in a very short period of time. I'm not trying to defend the doctrine of discovery in this answer. That is not the intention here. But it's important to note that even under the doctrine of discovery, the doctrine of discovery only gave the discovering European power the right to acquire the full land rights. And it was a right that was really against other European nations. So it's important to note that even through the doctrine of discovery, Britain didn't get all the rights, which is why you have the Royal Proclamation, which is why you have a treaty history in Canada, because the king knew that under international law, even under the doctrine of discovery as it's developed in the early 1800s by Chief Justice Marshall in the Marshall trilogy of Johnson and McIntosh and Worcester in Georgia and Cherokee Nation in Georgia, those cases that are foundational in Canada, the state still had to perfect their title. That's the word they use, right? So Britain got it right, but they still had to address Indigenous people's rights to the land. So it was definitely narrowing and was that process of slowly eroding and limiting the recognition of Indigenous people's rights. But it still did recognize that Indigenous peoples had rights to their land, albeit very constrained and problematic. And of course, the doctrine of discovery, this idea of underlying title is problematic. But even the doctrine of discovery did recognize the right of Indigenous peoples to their land, and how that played out in Canada in combination with the Royal Proclamation meant that the king, even from the king's perspective, he knew he couldn't just go and start settling, right? That's why we have this treaty history in Canada, was because from the king's perspective, as early as 1763, he knew he had no rights to the land unless he dealt with or treated with Indigenous peoples.
Mm-hmm. And you see throughout the history, I guess through international law and certainly in the history of Canada, the minimization of First Peoples' rights to the land or sovereignty in their territory, and you see that through, you know, a whole swath of legislation and policies. And so, and I thank you for that history. That was an interesting history of international law, and I think that puts a lot of context into how we arrived at where we are now. And to think, you know, of going forward and how we move forward. And I know you've discussed a couple of things on what Canada needs to do to bring itself within compliance with UNDRIP, for example, and looking at changes to Canadian law. What are some of the other things now, if we're talking about implementing UNDRIP and how it relates to the treaties, what are maybe some of the things that we could be looking at, the to-dos, right, as we move forward?
Brenda's top 5 to-do list. Yes. You know, one of the things that I think is incredibly important, particularly in Manitoba, from my perspective, is Manitoba has to give up the idea that the numbered treaties, Treaty 1 through 11, are land surrender treaties. When you look at what those treaties are, like throw out the text, and actually look at the treaty relationship, there is no basis for an assertion that First Nations gave up rights to their land. So Manitoba needs to accept that fact, 1, and then 2, start to address it, right? So start to work with First Nations to think about, what does it mean to share the land? And then 3, I don't know if I'm going to get to 5, but then 3, I think include Indigenous peoples in decision-making processes where their rights are specifically and especially impacted. And I would say, I don't know if it should be 4 or what, but I think the Manitoba government needs to not be afraid of this. Like, we don't need to be afraid of Indigenous peoples. And there's so many ways that we can see the government acting out of fear, and start to recognize that there's a lot of benefits to recognizing the spirit and intent of treaties and accepting this and finding new ways to work together and live together, right? The current relationship isn't really helping anyone, right? And so by engaging in these conversations in real ways and starting to work with Indigenous peoples, I think we can address a lot of the challenges that we see. I mean, if anyone wants to have conversations about how climate change is going, right, look to the West. Like, and I was reading a story that apparently there used to be a lake, I think, near where Abbotsford is now underwater, and you can sort of see how our attempts to control nature eventually comes back. And I think there's lots we can learn from First Nations about care and responsibility for land and how we can all prosper together, and that actually makes us all richer. But I think as long as we're stuck in this position that is just not grounded in anything, it holds us all back.
Mhm. I agree. And I think if you listened, to each of the speakers that we've had on, one of the messaging that comes across is throw out what you think you know, right? Throw out all of these things that have been holding us back. And fear, as you've mentioned, is a big part of that. This is the system, this is the Canadian system, and this is how it's always been. We even look at the Indian Act, right? In 1876, it's always been there in some form or another. We have to really shift our minds to thinking away from those types of things and looking again at the First Peoples and saying, they've always had systems. As you've said, they've come rich with their protocols, their ways of making treaty, and they haven't lost them. So it's going back to that original relationship, those original ways of treating each other and saying, okay, help us to understand this, right? And how do we move forward? And so we have to have those open minds, I think, as we go forward and get rid of some of that thought that has held us back, because it hasn't worked. It hasn't been working. So why not, try some of these, a different way of approaching things.
Yeah, and I think it can only get better, right? I think people are really afraid that somehow it's going to make Canada worse, but let's stop looking through kind of, I don't know, through rose-colored glasses or whatever those things are, right? And actually look at the reality of the situation. And I mean, people have different perspectives, but the socioeconomic condition of First Nations has impacts in Manitoba, and people may not necessarily realize that, but that has impacts. And if we have a better relationship, and if we can strengthen our nations and work with them, Manitoba is all going to be better for it. And I think people just need to start, and to really accept those realities and stop looking the other way. And at the NCTR, this is one of the things we talk about, is how the children really woke us up in this spring, right? And I think Canadians are starting to come to terms with it. And it's like, well, what do we do? Well, step one, recognize the spirit and intent of treaties and see the richness that brings to all of our lives.
And I think, you're right. Canadians are first, you get past the unknown or the lack or the ignorance of what that history is. And I don't mean ignorance in a negative way, but just not knowing what that history was. And then there's this denial that couldn't have happened. But you see a large segment now saying, we accept this, that this is part of our history and we don't want it to happen again. And you're absolutely right. I think that the NCTR, the work that has happened there with residential schools and the young children has opened our eyes, all of us, and saying we can't do this anymore, right? So we have to find different ways, and we have these tools that are there in front of us. It's just picking them up and figuring out that way of using them so that we can all move forward in a good way and reset the relationship, if that's the words that some people like. But it has to change. I think it absolutely has to change, and we have to look at sharing the land in a new way, in a different way, and not kind of in that colonial way of thinking anymore.
Yep.
So I think that brings us to the end. I don't see any more questions. And of course, we can probably go on and on. We didn't talk about, the distinction between the nation to nation aspect of UNDRIP, and then as you started to briefly touch on, some of those more specific rights. And so there's a lot here that we could still unpack, but I want to thank you so much for sharing your knowledge with us. And certainly at the Commission, we're so happy to have access to you to come on our Speakers Bureau and our radio show. And so it's wonderful. I truly value our relationship. And if you're doing international work and you need a sidekick, please think of me. I would love to expand my international aspect of the work that I do as well. So once again, Brenda, thank you so much for being with us. Thank you to everyone for joining us. And I have no doubt that you've learned a lot more about international law and its relation to treaties, about the United Nations Declaration on the Rights of Indigenous People and what that means for the treaties and the treaty relationship. And I encourage you to do more self-reading videos. I know Brenda has done a fair number. She has the guide. Please reach out and continue on your learning journey. Miigwech.
Thank you.